Hello students, a warm welcome to the Disha program. We are powered by Sarat Chandra IAS Academy. In Disha program, we are teaching and educating the young minds of our country, the young students about all sort of topics which will help them comprehend the world around them, whether these are national or of international importance. So in today's video, we'll be talking about the right to be forgotten. What is it? So we are talking about the legal right here. We are talking about the legal right here. So let's see. So why news first of all? So it's in news because the Supreme Court of India has agreed to hear a case whose outcome will likely shape the contours. Contours means the boundaries of the right to be forgotten, known in European Information Privacy Regulation as the right to erasure in India. All right. So what do we mean here? Right to be forgotten. That means if because of something you did, or let's say something that happened to you, you became a part of the information available on internet. Now in future you do not want this information to be available publicly, so you have a right to be forgotten. That means to erase this information and make it unavailable for the future. So the top court now has to decide, that means Supreme Court of India has now to decide whether the right to be forgotten is a fundamental right, and if so, how it relates to other fundamental rights guaranteed by the Constitution of India. So we'll have to see what are fundamental rights as well. Okay, so in the same video, we'll be seeing these things also. The acquitted man, acquitted means he was not charged of a crime, had moved to the Madras High Court in 2021, saying that he had been denied the citizenship of Australia because his name appears in the judgment that is publicly available on the legal portal. So he had not done any crime because he was acquitted finally by the court, even by the High Court, but only because his name is there present in the legal documents, he has been denied the citizenship of a country. So what would he want? He would want this name to be erased from the legal documents, or at least these legal documents not to be present on the internet. All right. So this case has gone to Supreme Court. All right, and this is what Supreme Court will be deciding now. Furthermore, so let us see what is the right to be forgotten. This we have already understood. However, we will see. So right to be forgotten can be loosely described as the right to remove one's digital footprints. Digital footprint mean from basically internet. Okay, where it violates the right to privacy. In May 2014, the Luxembourg-based Court of Justice of the European Union (CJAU), the highest court in matters concerning the application and interpretation of EU laws. So European Union. So basically Supreme Court of European Union, it affirmed that there exists a right to be forgotten, that this right does exist. Okay, it's not vague or it's not made up thing. It does exist. So, in what is commonly referred to as a Google Spain case, this case is very important to know. This is what the basis of right to be forgotten case. Okay, the court ruled on the plea of Spanish lawyer Mario Costeza Gonzalez to have Google remove information from 1998 regarding the forced sale of his property due to social security debt. So this was a person, this was a lawyer. He said that my name should not come in future on the internet, and this was granted. All right, and this case was known as the Google Spain case. Now, citing Article 7. So, EU also has its own law, its own constitution. They have different articles. These do not correlate with our articles or the articles of Indian Constitution. Okay, so Article 7 and Article 8, it basically tells the respect for private and family life and protection of personal data. Okay, of the EU Charter on Fundamental Rights. The CJAU ruled that search engines must cater to individual requests to remove data that appears to be inadequate, irrelevant, or no longer relevant or excessive in the light of time that had elapsed. Okay. So basically, an individual can request that remove my data from internet. I don't want it there because it is out of context now. Now in India, there is no statutory framework. In the last class, we also talked about the climate change law, the climate change law that Supreme Court of the South Africa, The president passed this bill. Okay, not Supreme Court, sorry. Okay, so they had made this mandatory carbon emission, etc. However, there is no such law in India. No such bill or bill passed in India, no such law in India. And again, we are seeing that there is no statutory framework for right to be forgotten. Right to be forgotten. Alright, so in India it does not exist. However, until 2017, there was a judgment of the Supreme Court, the K.S. Puttaswamy versus Union of India judgment, in which the Apex Court, whenever the Apex Court is written, it is to be read as the Supreme Court of India. Okay, under Article 124 of the Indian Constitution. Explicitly mean directly recognized the right to privacy as a fundamental right. It is under Article 21 of India, that means right to life. Okay, placing it as a facet of the right to life, right to equality, and the right to freedom of speech and expression. There were also questions on the right to privacy. Okay. Now, furthermore, the Supreme Court also said that this, let's say, this right to be forgotten, this right to privacy can be violated by the state. State means basically the government on some conditions, such as exercising the right to freedom of expression and information, for compliance with legal obligations, for the performance of a task carried out in public interest, on the grounds of public health, for achieving purpose in the public interest, and so on. Basically, what we can say that no rights are absolute. No rights are absolute. There are always some conditions. Okay, there are always some conditions. So what is saying that the Supreme Court also gave a list of valid justifications for the right to be forgotten to be violated. Okay, this right to be forgotten can be violated also. So no rights are absolute, despite it being a matter of, let's say, the fundamental right. Okay, now let us talk about some important cases related to the right to be forgotten. Right to be forgotten in India. So Rajgopal versus State of Tamil Nadu in 1994 only it started. Established the right to be let alone. The safeguarding privacy in personal matters, distinguished between public matter and private records, ruling that the right to privacy does not apply to public record like court decisions. There are other important cases also, such as Dharmraj Bhanushekar Dave versus State of Gujarat. It was in 2017. These are all very recent cases. So petitioner asked to remove detail of his acquittal in a murder and kidnapping case. Gujarat High Court refused, stating court orders are public record and should remain in the public domain. Okay, such names cannot be removed, even if acquitted. So this is the very big matter, let's say, for someone who is acquitted of such crimes. Their name will always come in the cases. Versus the Registrar General Karnataka in 2017. So protected the petitioner name in an annulment case, aligning with Western trends to protect identities in sensitive cases, particularly involving women. Okay, so now you can see the name redacted. This means the name is not public anymore. Okay, so this is the, let's say, real-time application of the right to be forgotten. The other cases also, Odisha High Court cases and Joravar Singh Mundi cases. So this you can read if you want to, if you are curious. Now let's quickly come to the other fundamental rights. So right to equality, we have 14 to 18. Guarantees equality before the law. Okay, prohibits discrimination on grounds of religion, race, caste, sex, place of birth, and abolishes untouchability and titles. Okay, it is only in front of the law and when it comes to the state. But in private matters also, these discriminations are not supposed to happen. Right to freedom, we have 19 to 22. Freedom of speech, expression, assembly, association, movement, residence, profession, etc., etc. Okay, and against arbitrary arrest and preventive detention. Then we have right against exploitation. Next, we have the right to freedom of religion, 25 to 28. It ensures freedom of conscience and the right to profess, practice, and propagate any religion, as well as freedom to manage religious affairs. The next, we have cultural and educational rights, 29 to 30. Protects the rights of cultural, religious, and linguistic minorities. You can read about the minorities in India to conserve their culture and establish and administrate educational institute. And this is the most important fundamental right, along with Article 21, the right to life. Right to constitutional remedies. That means any person, empowered individuals, to move the Supreme Court or High Courts to enforce fundamental rights through writs like habeas corpus, mandamus, prohibition, certiorari, and q warrant. We'll be reading about these in a separate lecture. Okay, so this is the end of the lecture. If you have any comments, any doubts, any feedback, you can let me know in the comment section. I'll be addressing those in the next lecture. So these fundamental rights we'll be reading in the upcoming lectures. Thank you very much. This is Yatharth here signing off. Have a great day ahead and see you soon.